Recently, an employer reached out in a scenario whereby an employee had stolen company property. And immediately, because of course they were angry, they quickly made a decision and they invited him to a disciplinary hearing. However, here is where the problem was. No investigations were done. No, even the CCTV footage that captured that was not checked. The employee was not given any notice to show cause. And that's one of the common mistakes I've noted from experience that employers make. Today, I'm going to share 10 common mistakes employers make during disciplinary hearing that cost them dearly. It literally leads to employers losing millions and millions of money in court. If you are new here, I am Ruth Tanui, an advocate of the High Court of Kenya and the managing partner of Ruth Tanui and Company Advocates. I advise employers on employment compliance and prevention mechanisms. As I had already stated, one of the common mistakes that employers make is failing to do investigation. Sometimes, from experience, employers are normally not doing it in a bad way. It's just that some employers act with emotions. So, for instance, the case I've just shared, the employer, it's true the employer had stolen, like there was even CCTV footage. But now you see here the mistake was the management just went straight to inviting this person. Basically, they went straight to finding this person guilty. Remember, it's not guilty until found innocent. It's supposed to be innocent until found guilty. So, despite the fact that you have gotten information regarding maybe an employee stealing company property, make sure you do investigation first to verify it and provide this investigation. If you do an investigation, do an investigation report and ensure that you give the employee this investigation report so they can defend themselves. The second common mistakes employers do is writing a vague notice to show cause. Many employers normally provide an employee with a vague notice to show cause. For instance, a common example is you write to an employee telling them that they have committed a misconduct and you end it there and you tell them not to, defend yourselves. But remember, the main purpose of the disciplinary process is to give an employee an opportunity to defend themselves. And there's no way an employee can defend themselves if they don't know exactly what they are being accused of. So that's why the employee needs to have all the information. What happened, when it happened, any company policies that they breached in the process, and also so that and any evidence that you have against them, so that at least they can present a very good defense. A tip I normally also give employers, in the notice to show cause, you can write at the end, please note that these are still allegations. We are still waiting for your chance to defend yourself before we make a conclusion. That's normally the best tip I normally give employers. The third common mistake employers do is giving employees little time to defend themselves. If someone right now gives you a notice to show cause and tells you accuses you of something and tells you must defend yourself by tomorrow morning, let's just be honest, will that be enough time for you to collect your witnesses, to get your evidence and everything? Of course not. And that's a common mistake employers do. I know sometimes as employers you have timelines. Of course, maybe you already made a decision, you're letting go of this employee. You need to do this within a week. But remember, court has been clear. There's even a case law. 24 hours is little time. You cannot just be acting as though you're taking a list. You have to actually give someone an opportunity to respond to any allegations. It's a notice to show cause that has been brought against them. So ensure you give an employee reasonable time. From experience, reasonable time should be between I normally say 3 days to 5 days. That is from experience. And also remember, this is just an example. It also depends on the context. Remember, if the accusation is very severe to an extent that someone might even lose like their license, you need to give more time. So ensure whenever you're writing that notice to show cause and you're giving an employee timelines, ensure you ask yourself, is this enough time? I normally advise employers, you can tell an employee they are free to ask for more time if they want. I feel that's the safest way. You can give 3 days and tell them if you need more time, you can ask for more time. That way you'll have protected yourself if an employee goes to court and says you didn't give them enough time. The fourth common mistakes that employers do is denying employees representation during the disciplinary hearing. Section 41 of the Employment Act talks about this. You must allow an employee to be represented. Some employers, however, because they feel this will waste a lot of time for them, normally don't give employees that opportunity. It ends up being expensive for them because, of course, if this employee goes to court and court finds out you didn't allow them to come with a representative, you have gone against the laws. It's not even your policies or the contract. This is against Section 41 of the Employment Act. So make sure you allow an employee to be represented. That's why we normally advise employers every time. So we normally advise employers to ensure that when writing them a notice to attend disciplinary hearing, you ensure you inform the employee. They can come with any representative of their choice. And if the employee is a member of a union, they can come with a union representative. It's for your own protection. So make sure you indicate that. I've had situations whereby when we're in court, some people normally say, some employers have the defense of the employee did ask to bring someone. Please note, it's your mandate as an employee, it's your mandate to inform the employee. It's not, it's not you to wait for the employee to ask for one. And remember, court will not look at whether the employee asked for one. Court will look at, did you inform them? The fifth common mistake that employers normally make is having a predetermined outcome. Remember, as much as you try to hide it, it normally comes out from the process. For instance, I've seen situations whereby the employer has already drafted a dismissal letter or a termination letter, and even they forget to edit the date. So you find the hearing was done on, let's say, on 5th. You find the dismissal letter is dated 4th. They forget to edit that because it's a process they are rushing. And of course, clearly, you already show it's a predetermined outcome. So please ensure that you don't make these mistakes. Or even, do you know, even court will, for instance, I've given an example of giving someone like 12 hours or less than 24 hours to respond to a show cause letter. Court will already see that as a predetermined outcome because clearly you don't want to give this person an opportunity to defend themselves. You just want to get rid of them. So be very careful. Remember, as I've stated, it's innocent till proven guilty. It's not guilty till proven innocent. The sixth common mistake employers make during the disciplinary hearing is normally poor record keeping. Remember, keeping records as an employer it's not a request, it's a mandate under the law. As an employer, you must keep records. It's actually stipulated under the Employment Act of Kenya. So common mistakes I've seen employers do is there are some employers who actually follow the law. You find they did everything within the book. They did investigation. They had a detailed notice to show cause. They informed this person they should come with a witness. But now the problem comes in, they didn't keep the records. Remember, burden is burden is on you in court to justify that you followed the disciplinary process. So if you don't have the evidence, of course, court will assume that process was not followed. For instance, I've seen the common one is disciplinary hearing minutes. People don't keep them, and now you find a situation where if the employee said the disciplinary hearing was unfair and you don't provide the minutes, court will assume that will agree with the employee because under the law you are mandated to keep records. So if you didn't bring the record, the employee was right. So ensure that you always keep records. Remember, an employee normally has 3 years after termination to sue. But the law even mandates you to keep it for 5 years. So ensure you keep proper records. Another common mistake that employers do is disciplining employees based on rumors. This is something you cannot risk as an employer doing because you find someone says that John stole, and then for you, without verification, you take the employee through the disciplinary process with no evidence, no justification, and you end up terminating them. Remember, some employees have disputes again among themselves, so someone may just want to get rid of their colleague. So make sure as an employer, whenever you make sure by the time you're disciplining an employee, that's why investigation must be done. It's based on facts, not rumors. That's why when there's any rumor that has been verified first before putting someone into a disciplinary process. Another common mistake that is honestly just sad is that employers don't follow their own policies. I've had scenarios whereby I'm advising employers where they made a mistake during the disciplinary process. And when I look at their policies, it's very clear. The policies are accurate. They have ensured that the disciplinary process is within the law. But now the problem is the HR or the person who was handling it just didn't follow it. So make sure you follow your own policies. I normally advise employers, do reviews of your policies frequently. You can get lawyers to help in training your HR annually or annually to just make sure you are at par. Because you spend a lot of resources ensuring your policies have been are up to date, and are in compliance with the employment labor laws in Kenya. But now the problem becomes the people who are mandated to follow don't follow it. I know it's become so sad because your only mistake now becomes that your policies were not followed. And remember, court frowns against employers who don't follow their own policies because it comes out as so careless. And that's why you'll see when it comes to compensation, court normally compensates. You'll find an employee will be highly compensated, especially in scenarios where the employers didn't even follow their own policies. Because court will just see that the process, there was even malice if you didn't even feel the need of following your own policies. So ensure you follow your own policies as employers. The ninth common mistakes employers make is failing to consider mitigating factors. Remember, when you're doing a hearing, you have to, before you make a decision, during the disciplinary hearing, you have to let the employee give their mitigation. Or you make sure you factor in mitigating factors. For instance, this employee might have worked for the company for over 20 years, or it might be the first offense of this employee. You're supposed to factor this in before making any decision. There have seen situations whereby employers go ahead to terminate an employee when it was actually a first offense, and even their own policies stipulate that if it's a first offense, it's supposed to be a warning letter. But sadly, you find someone. I saw a case whereby the employee was let go, yet according to their own policy, that was supposed to be a warning letter. So make sure you consider all the mitigating factors before you make a decision as an employer. As we have said, don't portray a fact that you had a predetermined outcome, like you're just ticking a checklist to, to ensure that you let go of this employee. Make sure you factor in mitigating factors. Remember, not all, I normally tell employers, not all disciplinary hearings should end up with a termination. One should end up with a warning. Some can end up with a warning letter, especially if it's a first offense. And most especially if it's your policy stipulate that should be a warning letter. So ensure you factor in mitigating factors. The 10th common mistake employers do is failing to give an employee an opportunity for an appeal. Remember, again, you cannot show as though you already had a predetermined outcome. And again, you must ensure that the employee is given ample opportunity to defend themselves. So it's important, especially if your policies provide for it, to give this an employee an opportunity to appeal when a decision has been made. And ensure you also, because normally give reasonable timelines. For instance, you cannot give someone 1 day to appeal. From experience, reasonable timeline for appeal should be at least 5 days to 7 days and just to make sure you protect yourselves, make sure this reflects in your policies. Because remember, if you give an employer an opportunity for them to appeal a decision and you're given reasonable timelines, court will clearly see that you followed the law and you actually gave this employee ample time. So ensure you give an employee a right to appeal when you're during the disciplinary hearing. Disciplinary hearings are not mere HR exercises. They are legal processes provided under the Kenyan employment laws that have consequences if they are not followed. So if you are a HR practitioner professional, ensure that you follow these processes to avoid significant consequences whereby it may lead to the company losing millions in court. My advice is normally don't wait to be served that demand letter or that court document. Ensure you review your HR policies and manuals frequently. Ensure you train your HR professionals to ensure that they're actually following those policies that have been reviewed. This way you protect yourself. Prevention is better before you end up losing the money. Don't wait until you're sued. If you have enjoyed this video, please subscribe for employment law insights for employment in Kenya. And if there's any topic you'd want us to cover, please feel free to share it in the comment section.